I see Commissioner Leclerc and Commissioner Hastings.
Good morning.
Morning.
Good morning.
Can you hear us okay?
Yes.
Yes, I can.
Terrific. Wow. Really have mastered the technology.
Now you do. I'm just.
Yep, yep.
Technology.
It is.
Nice tan, Commissioner Hastings.
Thank you. It all ends on Friday, though. We're heading back.
Well, welcome home.
We'll try to get rid of the snow by then. Okay, welcome to the March meeting of the Commission on Governmental Ethics and Election Practices. We have here 4 commissioners. We're missing Commissioner Newman, who wasn't able to be here today. So we'll start with item 1, ratification of the minutes of the February 28th, 2024 meeting. Would anybody like to make a motion?
I'll move acceptance with one tiny correction.
Okay.
On page 2, third paragraph, I think it should say Mr. Moore said he had not reviewed them enough.
Excellent, excellent catch. Any other amendments from commissioners? Okay, so it's been moved. Is there a second?
The second.
Been moved and seconded that we ratify the minutes with a small amendment. And we'll have to do a roll call vote because we have people remote. Commissioner Leclerc? I didn't hear you. I think you're muted.
I'm sorry. Yes.
Commissioner Hastings?
Yes.
Commissioner Marvel?
Yes.
And I'll vote yes. Okay, moving on to item 2, lobbyist registration with regard to harassment prevention training. And I'll turn to Mr. Wayne for a brief rundown.
Sure, and this concerns 3 different lobbyists, and 2 of them are here today to participate in the meeting. All legislators and legislative staff and lobbyists are required to take a once annual harassment prevention training that's organized by the legislature. And our only piece of administering this is that when lobbyists register, they have to certify that with us, they've taken the training, or they can ask for an extension, or they can claim an exemption, which may not be in the memo, but I just wanted to mention. Traditionally, we've given the advice that means you're exempt if you have been to the State House or the Cross Office building no more than 4 times. So because you've had such limited exposure to the legislative process and staff and other personnel, if you're barely in those public buildings under the law, that qualifies you for exemption. So we keep track of who's registered and who's taken the training and who hasn't. And trainings were offered through early February, and our records indicated that 3 lobbyists or lobbyist associates had not taken the training this session. And so we sent them notices of preliminary penalties, because one of the aspects of the statute is that the registrations are supposed to include the certification, and the commission is given the direction to reject a registration that does not include certification or requests for extensions or exemptions. So this is a new issue being presented to the commission due to COVID and other compliance issues. We haven't come to you in the past for determination on these penalties. 2 of the lobbyists, in our judgment, had an incomplete registration for 2 months, so the preliminary penalty is $200. In the case of a 3rd lobbyist, it's $300. And they're all requesting a waiver, and they've written emails explaining the reasons why they didn't take the training or could not. I'll let them speak for themselves. But in one case, one of the lobbyists registered on January 30th and only had a couple of days. And in another case, there were personal circumstances involving family. So preliminary amounts are $200 or $300, and it's your decision whether to grant or waive.
I have a couple questions though. First of all, why isn't the training recorded and available kind of on demand for people?
Well, the statute says it's supposed to be in person.
Does it?
And that actually is not even, well, first of all, this is outside our control. We don't, you know. After COVID, they moved away from it actually being in person, but they wanted, I mean, I'm inferring that they wanted some kind of interaction. So it's done through live Zoom meetings.
Okay.
And I actually think they have recorded it. My colleagues might know more about this. So, I mean, that's not generally the rule, but I think there are recordings that exist. That would make it a lot more practical for lobbyists, but that's just not the way it's written in the statute.
Okay. So what happens if someone, for example, in a couple of these cases, has failed to take it? What happens to their registration for the rest of the period? Are they not able to register for the rest of the session?
Well, they do file monthly reports. We don't feel, although we feel that, you know, we consider their registrations rejected, we don't think we're in a position to stop them from lobbying or suspend them from lobbying. It's more that they filed incomplete paperwork with us. So registration remains incomplete, but they continue to lobby and they file their monthly reports.
Okay.
Yeah.
Okay. Any other questions? Yes, Commissioner Mark.
Director Wayne, do I recall, and again, not that you're accountable for this, but that the training period is like early in the year and then ceases? Do I remember reading that?
Well, I believe the last training was February 2nd.
Right.
And that, you know, and that's a legitimate obstacle for some.
And then it is not offered, to your knowledge?
I believe that was the last training this year. So,
Yeah, you,
yeah, please, yeah.
so in the second sessions, the training is shorter. It's more of a recap of the previous year's training.
Right.
Typically during the first regular session, the training is offered a couple more times, sometimes in March. And last year, they did wind up offering a recorded version for folks who had missed any of the in-person ones. They were going to come before the commission, but they said if you attend one of the recordings and, you know, view the recording, we'll consider that good for this year. This year, that was not an option given to us by the legislative staff team that puts together the training. So it is kind of a weird kind of mishmash between who offers the training and us who have to make sure that they've taken it.
Thank you.
Any other questions from commissioners? Commissioner Leclerc or Hastings?
No,
No, all the questions I had have been asked.
Okay, great. Is Nicholas Bennett here? Please take a seat. Introduce yourself and go ahead and let us know what you'd like to let us know.
Okay, my name is Nick Bennett. I'm the staff scientist with the Natural Resources Council of Maine. This is my 28th legislative session lobbying, so I've been through this training many times before, and it's very embarrassing to have forgotten it. You know, as I look back on it, it's even more embarrassing because I missed the first set and called up, is it Amanda or?
Emma on our staff. Emma.
Yeah, but
Well,
I,
Amanda Goldson's
Yes.
training,
Okay.
it does
Thank
handles
you.
the training so much.
I called Amanda and she said, don't worry, there'll be a couple more. And things got out of control with work and it got to be February 3rd, literally on a Saturday morning. And I said, oh my God, I've just missed them. You know, I felt like I missed the first set because I had a death in the family and a sibling who was unconsolable. And I was just completely focused on that and trying to get my work done. And then we've had a very tough go of it because of some internal stuff at NRCM and trying to get my work done. And if it helps at all, I also forgot to register my car. I did not get pulled over for that. I finally remembered. But I just, you know, I don't feel like I've been very together for the past couple of months. And this didn't make it through the noise in my head, and I'm really sorry about it. I've been to enough of these to know that they're useful, and I get it, why we need them, and this is not what I wanted to do.
Thank you for your testimony. Any commissioners have questions for Mr. Bennett? No. Thank you, sir.
You're
Appreciate it.
welcome, thank you.
Is Mr. Chant here?
Yeah.
Did I pronounce that anything like?
Yeah, that's good.
Okay. Please introduce yourself for the record and fill us in.
My name is Jennifer DeChant, as you pronounced correctly. And I am here as, it seems odd to even be referred as a lobbyist because it's like not my thing. And it is, I do government relations, so I work with lobbyists. I have the pleasure of doing that, but I registered as a lobbyist on January 30th. Out of an abundance of caution because I was just had this special project that I was working on. And so, and I wasn't aware of the waiver or the extension. It was January 30th. I was consumed with, I don't know what I was consumed with, but not knowing the nuances. And so I am as embarrassed that I missed that. I understand its relevance from previous experiences in the legislature and in city council. But I also know that I will press 0 for the next 11 months because I'm not doing this. I'm not, so anyway, that's what brings me here today. Is that it was done as an abundance of caution. I'm not a lobbyist. I won't be lobbying from this point forward. And I'll press 0 every month. And it just happened so quickly that I didn't realize that I missed the one opportunity to do the training.
Thank you. Thank you for your testimony. I have a question. Have you ever registered as a lobbyist before? Okay, thank
And I probably won't again.
you. Okay.
But we're not to take that as you're demeaning.
No, I rely on that expertise.
Any questions from commissioners?
No,
No,
Thank you very much for your testimony. Mr. Smith? Okay, Mr. Smith apparently is not here. And we have, Mr. Smith's response in our packets. Okay, so we need to decide what to do, in these cases. We have 3 cases. They differ somewhat. I think we ought to, handle them one by one. So with respect to Nicholas Bennett, I think it's clear that he's violated the requirement. And he's an experienced lobbyist. I think I would move that he's fined $100. Is there a second? Not hearing a second, I'll ask for other motions. Well, we have to have a motion to discuss it, so.
I guess I'll move for a fairly minimal penalty in this case. $25, and given his explanation, the fact that he has acknowledged an understanding for why the trainings are important, that he's seemingly attended them in the past. I'm even reticent to make that motion, but I will so that we can open up some discussion. I'll make a motion for a $25 penalty.
Is there a second?
I'll second that.
Okay, it's been moved and seconded that we impose a penalty of $25 on Mr. Bennett. Discussion.
I guess so my understanding of this system is that the legislature itself runs the training, that they require some sort of live component, and whether it's an assisted video or an actual live program. I'm also understanding that at least in the past year, they had extended the availability of those trainings into the month of March. Did I catch that correctly?
Emma was saying that they offered a recorded version last year in March.
And that has not happened this year. Um, uh, um, and so the status of Mr. Bennett's registration is that he, I guess so that's what I'm confused on. Maybe Mr. Wayne could explain that again.
Yeah, it seems that his registration is incomplete and it will continue that way, although he won't be barred from lobbying. Is that correct?
Yes.
Okay. I don't know if anybody else wants to comment, but that's it for me.
Commissioner Marvel?
Just basically in agreement. I think we're all in agreement, speaking for other people, that the training matters, that the content is relevant and matters. I think that there are perhaps limits on the availability of training that have not been conducive to people who are either new or otherwise burdened with other responsibilities to take advantage of this. I don't want to not assess any consequence for a couple of reasons, but I think given all that we know, $25 is a fair, if slightly token, consequence.
Anybody else? Okay, it's been moved and seconded that Mr. Bennett is assessed a fine of $25. We'll do a roll call vote. Commissioner Leclerc,
Yes.
Commissioner Hastings,
Yes.
Commissioner Marvel,
Yes.
and I'll vote yes as well. Moving on to Mr. Chan. Does anybody have a motion there?
I think while I'm not trying to suggest that the people or the situations are identical, I think for some sense of consistency, I would move that we fine him, her $25 as well.
Is there a second?
I will second that, yes.
Okay, it's been moved and seconded that Mr. Chant is fined $25. Is there discussion? I'll say that. Oh, go ahead.
No, please.
I was just gonna say, I'm very sympathetic to this. Somebody who's never lobbied before, who registers a couple of days before the last training, I think has a pretty legitimate reason not to have had it occur on the radar, and I feel sympathetic, so I'll just say that. Anybody else?
No, thank you.
Okay, so it's been moved and seconded that the fine is $25 for Mrs. Chan. Commissioner Leclerc,
Yes.
Commissioner Hastings,
Yes.
Commissioner Marvel.
Yes.
I'll vote yes as well. For Mr. Smith, do we have a motion? It's a similar circumstance to Mr. Chant. He registered on January 31st, 2 days before the training. Is there a motion?
Mr. Smith is not here.
Correct.
But I did read his explanation. I see no reason this morning to veer from what we've been doing. He's a single person lobbyist for broadband. Is that like internet service in rural communities, or is?
I assume so. That's what it sounded like.
So, I'll move that Mr. Smith be penalized with a $25 fine.
Second.
Okay. Is there a discussion? Okay, we'll move to a vote. Commissioner Leclerc,
Yes.
Commissioner Hastings,
Yes.
Commissioner Marvel?
Yes.
And I'll also vote yes. Thank you very much for coming in. We appreciated the information.
Thank you.
Thank you. Thanks.
Okay, moving on to agenda item 3. This is the rulemaking that we've been working on. For the barring foreign governments from election spending. And in looking through this and in thinking through this, well, let's have Mr. Wayne kind of brief us first.
Sure. As the chair mentioned, Commission started a rulemaking in January to implement this new law that prevents foreign governments from spending money or making contributions to influence elections in Maine. And we had a public hearing on February 28th. And then on the next day, February 29th, U.S. District Court for the District of Maine granted a motion for preliminary injunction. So as of right now, the commission is enjoined from enforcing the statute. We received comments from 8 organizations through the deadline, and staff has looked at those comments and we've conferred with our counsel. So what we presented in our 2 memos here today were our suggested revisions to the amendments that were proposed in January. And we received a suggestion from our counsel that if you would like to, with these revisions or something like these, that are somewhat of a change from the original amendments that we proposed, if you'd like to move in that general direction, it might be advisable to ask for a second round of comments. And we could do it a couple of different ways. Your next scheduled meeting, well, maybe I should hold off right there, but your next scheduled meeting is May 29th. We could do comments in a couple of different ways. I'll just stop right there.
Yeah, okay, great. So it seems to me that we have the threshold issue really is whether we proceed with this rulemaking or not. We have an option to suspend the rulemaking until the court has decided in some kind of final fashion whether this is a permissible or constitutional provision. So I think the threshold issue is whether or not we proceed with the rulemaking. And I'll move that we do proceed with the rulemaking. Is there a second?
Second.
Okay, it's been moved and seconded. Is there discussion?
I just had a couple of questions. So what was the deadline for people to submit comments?
March 11th, I think.
And when was the court decision from, I think it was Judge Torrenson or?
Yeah, I think it was the 9th.
29th of.
Oh, 29th, sorry.
The 29th of February that came out?
Mhm.
And does commission staff have any opinion as to whether the news that the matter had been enjoined would have impacted or likely impacted anybody's submission of comments for that last week or so?
Right,
other-
well, we did. Sorry.
Well, I think I'll just leave it at that. That's my question.
Sure. No, in 5 of the comments we received, they were submitted after that preliminary injunction, and they take into account the preliminary injunction. The 4 challengers to the law are arguing we suspend the rulemaking. The Campaign Legal Center, which is a reform organization based in DC area, they suggest moving forward with the recommendation, or I think that's sort of implicit in their comments. So our commenters definitely had the chance to consider the injunction.
So you don't believe that there's anybody that was discouraged from commenting based upon the news of the law being enjoined?
I really don't have a way of knowing. Certainly some of the folks that cared the most about it understood they could comment and went ahead, but we don't know. For the people that we didn't hear from, we don't know.
Yeah.
What
Okay.
motivated.
Commissioner Hastings.
Yeah, I'm a little bit confused here. Jonathan, what you're proposing today include revisions from the original proposed rules, does it not?
That's correct.
Could you go over those and let us know what they are? And it does contain a provision that these rules would not be going into effect it's until such time as the injunction has been removed.
That's correct. I'm gonna get to that. I think the first step we need to take though is to decide whether we're gonna go ahead with this whole rulemaking process or whether we're gonna kind of put it into abeyance for a while until the court issue is resolved.
Well, then I'll be happy to comment. I think we should go ahead with it with the proviso that they shall not be enforced pending the resolution of the injunction. And it makes sense to at least, once the injunction, if in fact the injunction, if the law is found to be constitutional, that the commission be ready to enforce it immediately, not wait several more months while it then works through the rule process.
Commissioner Hastings has just stated exactly what I was thinking.
Mhm.
Commissioner Marvel.
And I want to agree with that. And I also want to add that this is an important enough issue that I'm in favor of any and all time made available for dialogue and comment. I think this matters. I don't think it's anything that should be abbreviated now and just picked up in the future. At some point under your discretion, I'd like to just throw out a philosophical observation about First Amendment in all of this, but it's not a critical matter.
Maybe that is better when we discuss what these changes are.
That's fine.
Okay, does anybody have any further discussion of whether or not to proceed with rulemaking?
No.
Okay, so I'd like to take a vote. It's been moved and seconded that we proceed with rulemaking. Commissioner Leclerc,
Yes.
Commissioner Hastings,
Yes.
Commissioner Marvel,
Yes.
and I'll vote yes as well. The next question, I think, is whether we change the proposed rules or not. And this is not weighing the specific changes. This is just deciding whether or not to proceed with the rules as they were proposed or whether to make some changes to them. And we've got some recommendations from changes from Mr. Wayne and Mr. Bolton. So I will move that we consider making changes to the rules.
Second.
Is there discussion? Okay, Commissioner Leclerc,
Yes.
Commissioner Hastings,
Yes.
Commissioner Marvel?
Yes.
And I'll vote yes as well. So the next question is what changes we make, and Mr. Bolton and Mr. Wayne have proposed a whole series of changes. This is when we get to Commissioner Hastings' question about what those specific changes are. Mr. Wayne, Mr. Bolton, would you like to kind of run us through these?
Maybe I'll leave the legal aspects in sections 9 and 10 to John, and then I'll do the others if that's okay.
Sure.
Okay. So, we're suggesting a couple of revisions to the definitions. In the original amendments, the commission had proposed, what does it mean to directly participate in the decision-making process and indirectly participate? And those definitions focused on communicating a direction or a preference as part of a decision-making, concerning the outcome of a decision-making process. And we received some suggestions on that. So what we are now suggesting or recommending is to define the term participate, which in a decision-making process, which would mean to deliberate or vote on a decision with the invitation, consent, or acquiescence of the firm or the association that's making the decision. So it's a narrower definition that we think addresses some of the concerns that were raised with us. And then that definition of participate is incorporated into the definitions of direct participation and indirect participation. And let me just say, I'm referring to pages that are numbered 10.
and 11 and on from there.
Yeah, so in our draft statement, they're discussed in our larger memo on 10 and 11. And then the actual insertions and deletions, if you care to look at them as I describe these things, are on ETH 1 and
Yeah.
ETH 2.
Great.
Yeah.
And I want to encourage commissioners, I don't want me to interrupt you,
Yeah,
but
please.
I want to encourage commissioners to ask questions if you have any as we're going along, so that we don't kind of miss them. Okay,
And then another definition that we're recommending a revision on is the definition of indirect beneficial ownership. Because if a foreign government indirectly owns an entity that's spending money in a Maine election, and has more than a 5% interest, that counts as ownership. So what we just adopted a second example of what does it mean to indirectly own an entity that is spending money. So this was suggested to us by the Campaign Legal Center. We think it's a good example, so we'd like to insert that.
and now I would like to ask a question. From an enforcement point of view, how the heck are we gonna know that?
Well, I think our feeling is that we hope in large part compliance is achieved because the entities that want to raise and spend money on Maine elections are going to self-regulate. I know that's not enforcement, but
No,
That's how we hope.
That's always the goal.
yeah, I mean, I think that if a situation is brought to our attention as part of a complaint, because if we don't have the staff to be aware of all the election spending and figure out who owns what, it would mean someone has to file a complaint. There could be challenges, especially if foreign entities are involved, but we would use our usual investigative techniques of asking factual questions and requiring documents and that kind of thing, interviews.
This will,
I would just add to, if the corporation is publicly traded, then a lot of that information is easily accessible.
right, I was thinking about though, if I have an S corporation, and I sell stock to Mercedes-Benz or some foreign corporation, there's no way to know that. There's no filings required or anything.
Yeah, that's right. There's definitely enforcement challenges with some types of these entities.
Yeah.
Question.
Okay, okay. Thank you. Any other questions about that? Okay,
Then one more definitional change we recommend is with respect to what does it mean to structure financial activity? Because one of the prohibitions in the statute is structuring financial activity in order for foreign government spending on an elections to be sort of concealed or facilitate a violation for structuring a transaction. And we received a minor language suggestion from the Campaign Legal Center. This concerns an example. What does it mean to structure? One of our examples in the original amendment is creating a business entity whose ownership is difficult to ascertain. And their suggestion was a business entity whose ownership cannot be readily ascertained, which they feel is more clear. And
kind of a happy to glad change.
yeah, so we're comfortable with that change, so we would recommend that. Then we get to the disclaimer that is required for certain communications. Most of what this law does is prohibit spending to influence elections in Maine, but there is also a provision in the law that relates to paid communications to influence policy, government policy. So if the context here in the statute is if a foreign government owned or controlled entity is spending money to influence the public or any state or local official regarding any state or local government policy or regarding the political or public interest of a foreign country or a foreign political party or government relations with that foreign country or political party, those types of paid communications need to include a particular sponsorship message that says sponsored by, and then the name of the entity that made the payment for the communication. And then there needs to be a statement under the statute that identifies that entity as a foreign government or a foreign government influenced entity. So in the rule, as we originally proposed it in January, the sponsor of the communication could include additional truthful and accurate information describing the entity. And the suggestion from the Campaign Legal Center was that if we're allowing too much variation and in these disclaimers, it will confuse the public, and in particular, we might be called upon to decide what is an accurate or truthful statement made as part of these sponsorship messages, and that puts us in a delicate situation. And so their suggestion is limiting the additional information just to a statement that says sponsored by X, a foreign government or a foreign government influenced entity as defined in Maine law. Sorry, that was really a longer explanation.
No,
There, but they're suggesting really as defined in Maine law could be the additional clarification that could be added to a sponsorship message, but that would be it.
That was
Yeah.
very clear.
Okay, and that makes sense to us. So we recommend that.
Okay. Any questions from commissioners?
Just a request that as we're going through this, as much as you can, keep referencing where we are in the document.
Absolutely. Sorry.
Thanks.
Yeah, that language was on ETH 4-4.
Okay. And the discussion is on ETH 16.
And then the last section I'm going to talk about is the requirements for media providers, because under the statute, media providers are required to adopt due diligence policies and procedures and controls that are reasonably designed to ensure that they don't broadcast or distribute basically campaign ads that are funded by foreign governments. So that's a requirement for cable and TV stations, print news operations, and other media providers. And now I'm referring to page ETH4 and ETH5. Those are the insertions and the deletions, and then
17 and 18.
thank you. Yeah, 17 and 18. Okay, so we're recommending a change proposed by the Campaign Legal Center that confirms that, well, actually, let me take a step back. What we are attempting to do in this section of the rules is to lay out the terms of what would be an optional safe harbor policy. So this would be not required, but an example of the kind of policy and procedures that a media provider could adopt that our commission would be saying, if it contains these 5 elements, we are considering that to be compliant. We're considering that to be sufficient to be reasonably designed to prevent the broadcast or distribution of these elements. Media providers would not have to adopt this exact policy, but we wanted to come up with something that was practical and low cost that media providers could implement that would be reasonable. So one of the suggestions from the Campaign Legal Center is a clarification that in all of these policies and procedures, whether they adopt our safe harbor policy or not, nothing in our rules would be interpreted to prohibit or otherwise restrict a media provider from reproducing a campaign advertisement that was prohibited as part of a news story or commentary or editorial. We think that's a very good clarification to make. That was our intention. So we would recommend that revision.
Sure.
This is gonna risk not a rabbit hole, but a little confusion because I'm not clear on something, and this is where I'd like to try to clarify. So the worst kinds of offenses are clear to me. They're all around money. What I don't remember as clearly as I'd like was that at the previous meeting, concerns expressed by like the Maine Association of Broadcasters about limitations, and I know they were citing First Amendment issues. And driving down here this morning, I'm thinking about this and I'm thinking, well, coverage is one thing, editorial expression is another, and revenue is a third. And to me, it's sort of about where those things do or don't intersect. And I would appreciate any observations from any of the experienced attorneys in the room on this. Because what I don't want to do inadvertently is personally support something that intentionally or not clouds that issue. And I mean, it seems apparent to me, the idea of we're gonna replicate this ad that we do or don't agree with, because that's not the point, simply as part of coverage of this campaign. That sounds innocuous to me. But there were messages expressed that concerned me a little, that to me could have been addressed by saying, well, we'll save that for editorial policy. So I'm not sure what I'm asking. Part of this is, what is the press's perspective on this and your opinions? What are they truly concerned about? And are we addressing what we think we should be in the spirit of the law on this issue, as expressed by the voters?
Sure, I can try and answer that. I mean, I think when we were looking at how to craft this, I mean, one of the things we're cognizant of is this is not a law aimed at the media. This is a law aimed at foreign government influenced entities.
Right.
And so these media provisions are secondary, and they're a way to ensure that the law is as effective as possible. But because, you know, this is sort of a secondary enforcement aspect of, it's a secondary aspect of making the law as effective as possible. You know, we try to craft these laws in a way that keeps the burden as, you know, as low as possible on the media, that's still consistent with legislative intent. And with this specific language, I think what we're trying to get at is, I think what the law is and the voters were concerned about is advertising, right? With media, I don't think there was a concern about, you know, editorials that quote from, you know, potentially, you know, now illegal foreign government influence campaign ads. So the idea is to draw a distinction between, you know, editorial speech and other kinds of speech that this law is really not directed at, and, you know, shouldn't be directed at, and the kinds of sort of, you know, commercial advertising that I think is more in line with the legitimate policy goals of trying to make sure that these foreign government influence entities are not influencing elections. I don't know if that answers your question.
Not 100%, but I think that's probably at my end, not yours. No, none of my fellow commissioners have a related concern. I'm fine. I just wanted to raise it, throw it out, see what happened.
Any questions or comments from Commissioner Leclerc, Commissioner Hastings?
No.
No, thank you.
Okay,
Thanks.
I want to throw out a hypothetical to kind of test this a little bit. What would be our office's response to a TV ad bought by the province of Quebec that says New Hampshire and Maine, hydropower is very important to you, and you should always vote to further the availability of hydropower in your states at the time that there's a referendum going on in the state of Maine? Great question.
So I think we have to think about whether, you know, whether that ad would fall within the prohibition or the disclaimer requirement, whether it was, it's an ad that would influence, that it, is aimed at influencing the referendum election, or whether it's just an ad on general policy issues. It sounds like in the context you're talking about, where there's an upcoming referendum and, it would, the ad seems to be suggesting of people vote a particular way in that referendum, probably would fall into that latter category, but it would depend, right? This is why we have to have a commission meeting and
We get to make the hard
watch the
decision.
ad and we try to make that determination. And how clear cut is it and what do we think? So I think the answer is it could, but I think you'd have to look at the ad and decide whether it was intended to influence an election or whether it was just more of a general sort of statement of policy, in which case it probably would just need to have that disclaimer at the bottom that says paid for by what government says.
Are the rules that we're proposing adequate to equip us with the tools and information that we need to deal with something like that?
I think that particular, example is fairly similar to some of the kinds of like the independent expenditure questions that the commission sees all the time. So I definitely, I don't think that particular issue is probably something that these rules sort of focus on, sort of drawing that distinction. I think because again, it's the kind of thing that comes before the commission in other contexts, but that's certainly something we could look at. Trying to think through that more and provide more specific guidance there as to when it becomes sort of electioneering.
May I ask a question based on your question?
Please, sure.
Would it make any difference if instead of Quebec, that money came out of Calgary?
No, the law defines foreign governments as including political subdivisions of countries. So
And
the city,
that the referendum contains specific references to sources of power within an existing power company that operates in Maine that's owned by a province in Canada, to my knowledge.
the law wouldn't draw any distinction there. So it's not. It covers all referendums. It doesn't matter what the content of referendums.
Would it apply to an LD that's been proposed in the legislature?
No, it would not. I mean, unless if the foreign government influence entity wanted to run some sort of advertising.
That's what I'm asking.
Yeah, saying you should call your legislators to
Right.
vote down this. It may trigger the disclaimer requirement where that advertisement would have to say at the bottom, paid for by a foreign, this entity, a foreign government influence. So that's where it would kick in. But no, it doesn't. It only applies to elections, referendum and candidate elections.
So
In terms of the prohibition, I've got to keep these separate. The
Right.
prohibition where you can't spend is limited to candidate and referendum elections. The disclaimer requirement covers other sort of issues that involve the interests of the foreign government or other sort of public policy matters relating to the foreign government. In those cases, if you're doing a public communication, which is basically an advertisement, you have to have the disclaimer at the bottom. So it doesn't cover, like, for instance, lobbying, where there's no public communication, there's not a mass market type of communication, right?
aspect for communication.
So
Other questions or comments from commissioners?
No,
Okay, Mr. Oh. Were you going to say something, Commissioner Leclerc?
I didn't have any questions.
Okay, great. Mr. Bolton, would you like to talk about the activation provisions?
yeah, I think this is fairly straightforward. And obviously, this law is currently preliminarily enjoined, which means we are not permitted to enforce it. And I think even if these provisions weren't in the rules, we wouldn't be permitted to enforce the rules clearly under the current injunction. But I think just because it was my recommendation that we include this language for two reasons. One, I think we want to be absolutely clear to the regulated community, to the court, to the public, that, you know, as long as this law is enjoined, we're not going to take any action to enforce it. I think that's probably the most important thing. And I think the other reason for these provisions and is that they address this issue of severability, which has already been an issue in litigation. I think will continue to be an issue in litigation, which is if it turns out that there are parts of the law that are unconstitutional, but other parts that are constitutional, the state would take the position and has taken the position in litigation that the constitutional parts should be allowed to go into effect, even if other parts are enjoined. So these provisions make sure they again, if these weren't in here, I think that would probably still be the result, but we want to make it absolutely clear that that would be how the rules would operate in that circumstance where we got a decision that, you know, part of the law is unconstitutional, but not the whole thing. So that's I think that's it for those two provisions.
Great. Commissioner Hastings, did you have a question or comment about that?
No, I think
Okay.
it's appropriate.
I will move that we proceed to make the changes that have been recommended by the staff to our proposed rules.
Second.
And there's a second. Discussion.
I have a question.
Yes, please.
Are we going to request additional, are we going to open it up for additional comments?
That my proposal was gonna be that would be the next question we deal with.
Okay, then thank you.
And did you want to say something?
I can wait until that discussion.
Okay, great. Yeah, are there further comments or questions about these revisions that staff and Mr. Bolton have suggested?
I'll just say I respect the process and I think the content is thoughtful and appropriate. So very comfortable supporting it.
Great. So we'll go to a vote. Commissioner Leclerc,
Yes.
Commissioner Hastings,
Yes,
Commissioner Marble?
Yes.
And I'll vote yes as well. And I think the last question that we need to deal with here is whether or not to reopen the comment period. And Mr. Bolton wanted to address that.
Sure, so the reason why staff has proposed that we do this, which at my advice was, there's a provision in the Administrative Procedure Act that says if the rule adopted by the agency and the term is substantially different than the proposed rule, then we are required to put it out for an additional 30-day comment period, which does not need to include a public hearing, although it can if the commission wants to do that. In this case, I think in particular, some of the changes to the direct and indirect participation this is your decision, not mine, whether it's substantially different, but my view is that those changes are significant enough to make it a substantially different, at least those provisions are now substantially different. So I think my advice to all clients is err on the side of caution with this and do the comment period if there's any doubt. And if there's no, incredible time pressure, which there's not in this case. So my fairly strong recommendation is to put it out for a second comment period.
And my thought is, regardless of whether it's substantially different or not, I think it's only right to allow an additional comment period for changes like this. So, Commissioner Hastings.
yes, and I do too, and I was a little concerned at the last meeting that, for instance, the broadcasters did not address the rules in any way whatsoever. They were relying on their opposition to the constitutionality of the rules. And I would hope that the parties and essentially the stakeholders that have to deal with this would, in spite of the injunction, recognize that there's a possibility that this law will be found constitutional, and I would like their input. I would hope we could have their input as to these rules in the event that they are found if the law is found constitutional. I just hope that they would make their qualified, take a look at the rules and see how they affect them. They may have other comments that we would be willing to listen to.
I agree 100%. So I'll move that we reopen the comment period for an additional month. And is there a second?
I'll second that, and I have a question.
Okay, great.
Staff have any recommendation as to whether or not that should include another public hearing? Are you confident that you'll get the response we're looking for via an extended comment period?
Yeah, my view is you don't need to do a second, public hearing. I think all the interested parties, at least a lot of the people you would expect to be interested in this have already provided comments. I'm sure they're following the
They have it on
rulemaking
their
process. And I'm sure they'll be ready to provide additional, written comments. So you certainly can if you'd like, but I don't see it as necessary.
That's my feeling.
Thank you.
Any other discussion about whether or not to reopen the comment period for another month? Okay, we'll proceed to a vote. Commissioner Leclerc,
Yes.
Commissioner Hastings,
Yes,
Commissioner Marvel.
Yes.
And I'll vote yes as well. Terrific. I think, yes, please.
Can I ask a question? And
You may.
this is actually for our council,
Yeah.
just to sort of, maybe help my understanding and possibly others who are in the room or listening. And I'm not asking this question in any way to restrict the comments. It's just really more of a clarification.
Yeah.
Or in terms of how we word the invitation to comment. We're inviting comments on the changes.
That's right.
To the January amendment.
Yes.
That's correct.
So if somebody wants to comment on maybe some provision that no one ever commented on first, then there are no revisions to it, like there's no discussion previously. Are we open to receiving
I think
those or not?
We should ask for comments specifically on the changes. If we, despite that, receive comments on the original rule, we can talk about how to appropriately deal with that in the response to comments that we file with the Secretary of State.
Mr. Bolton is wicked smart.
Mm-hmm.
Great, thank you.
Sure.
Yeah.
Okay, so I believe we're finished with agenda item 3. There's something marked other business. It's a table about qualifying contributions. Do you want to discuss that, or is that just kind of informational?
Well, it relates to scheduling, so I'll just say a quick word on that. And I actually have a second item of other business relating to our staff here. This was really just intended as an FYI that April 22nd is the deadline for the candidates to submit their qualifying papers to qualify for the Maine Election Act funding. And the staff makes a decision on each and every application. Most of them, the vast majority of them have met the requirements. Occasionally, however, we find flaws in either the way the contribution was made or how it was documented. That means we have to invalidate some of them, and sometimes we have to turn a candidate down, and there could be an appeal to the commission. So this was really just meant as a general FYI to the commission that we do have written internal standards for how we go about looking at these defective qualifying contributions. We have standards on whether or not they can be fixed, and generally they can fix them if there's a problem with the documentation or a problem with the way the contribution is made before the deadline of April 22nd. But in almost all cases, our staff policy is not to allow them to make the fix after the deadline. And it was just meant as a preview in case we get any appeals. We just wanted to sort of be clear about how we go about doing this.
Terrific.
Yeah.
Are there questions from commissioners?
No. No.
Okay, the other item?
The other item concerns our staff, and it's kind of a sad note. You heard earlier today from Emma Burke, who's our political committee and lobbyist registrar. She's been with us for 10 years, and she accepted another job that relates to elections in another office within the state. But before you hear from her and her job, I just want to say on behalf of the entire staff, she's been really critical to our advancements and development of our policies in the office. She's extremely dedicated, extremely organized and reliable. She's got a knack for identifying gaps in our administrative procedures and figuring out a better way to do stuff. So she's been responsible for a lot of good things that happen here. She's been here 10 years and we're gonna miss her, and just want to acknowledge her great work.
We'll miss you terribly. I think you serve as the face of the commission to the world. I mean, you deal with all the candidates every day. I just can't thank you enough for your service. It's been remarkable.
And don't we have any option to not accept a resignation?
We'll have to fight the Secretary of State over that.
Happy to.
I'll do that.
Would you
I,
like to say anything? Oh,
Oh,
I would like to say, Emma, I think the world of you, and very much appreciate the work that you've done with the commission. And I'm very sorry to see you go. Good luck. Wherever
I'll
you go.
second that.
would you like to say anything?
so my new position is, it's a new office under the Secretary of State. I'm going to be the new Director of the Division of Election Audits, under the Secretary of State. Maine, as of now, does not do any post-election audits.
Right.
And there was a law passed a couple years ago to have the state start doing that. So I'll be the Director of that division, under the Secretary of State. So, still be directly tied to Maine elections, which I care very deeply about. It's a very hard decision to leave ethics after 10 years, but I'm confident knowing I can go there and be a good boss and do great things for Maine elections after being here for so long and learning from the best. So,
Well, it's an exciting prospect. I think it'll be interesting to stand up a wholly new function like that. Yeah.
we have to have a pilot by November.
Wow.
Yeah.
Wow.
So,
That's great.
yeah,
That'll be a challenge.
yes.
Well, again, thank you so much for your service, for your dedication. I know that you spent late hours sometimes here helping candidates figure out the election laws and helping lobbyists get compliant with the laws. And I can't thank you enough for that.
Okay, appreciate
And with that, would anybody like to make a motion?
I move we adjourn.
Is there a second? It's been moved and seconded that we adjourn. There's no debate or discussion required. We'll go right to a vote. Commissioner Leclerc,
Yes.
Commissioner Hastings,
Yes?
Commissioner Marble.
Yes.
And I'll vote yes as well. Thank you, everybody.
Okay, and
Thank
there's
you.
no meeting next month now, right?
Correct.
That's right.
Oh, well, provisionally, there may be a short notice meeting if someone has not qualified for public funding and wants to appeal it.
Okay. Thank you.
You bet. Great to see you. Go back to the beach.
All right.
Safe travel.
it. Send them pictures of the ice storm.
I just don't want to find out that you had no influence in any way on the draft language behind that law that was passed 2 years ago.
Which one? For the
That
audit?
created,
No, I.
Yeah. yeah. Augusta's a small place, and you've got a lot of connections with a lot of